The apparent intentional caused his genital organ to penetrate that of a minor, GAI, Somali female aged about 18 years without her consent. Additionally, the apparent also faced an alternative charge of committing an indecent act with an adult contrary to Section 11, subsection 1 of the Sex Offences Act, based on same particular. The parent has appealed his conviction and sentence. The original petition of appeal was filed on 23rd December 2019. His counsel Nyaga filed a supplementary petition of appeal on 5th February 2020 and listed 17 grounds which I have reproduced in this judgment. Parties agreed to dispose appeal by way of written submissions. The parent filed their submissions on 13th February 2020 and filed on even date. The respondent obtained through Mr. Mulati submissions but considered the appeal. However, the complainant via Mr. Nipor, who was watching brief, filed their written submissions dated 12th February 2020 and filed on the even date. The matter came up for hearing on 20 February 2020 when parties highlighted their submissions. The court has summarized the submissions. I don't have to reread them. It's quite lengthy. You get a copy. We'll just do this. And the evidence, submissions and evidence on the issues analysis. The duty of this court as a first appellate court is to evaluate the evidence and draw independent conclusion, as was held in the case of Okeo versus Republic 1972 EA, page 32, that appellant on the first appeal is entitled to expect the evidence as whole to be subjected to fresh and exhaustive examination, and to the appellate court's own decision, and an appellate court to make its own decision on evidence. The first appellant court must itself weigh conflicting evidence and draw its own conclusion. It's not the function of the appellate court merely to scrutinize the evidence to see if there was evidence to support the lower court's finding and conclusion. It must make its own findings and draw its own conclusions. Only then can it decide whether the magistrate's findings should be supported. In doing so, it should make allowance for the fact that the trial court has had the advantage of hearing and seeing the witnesses. Close the quote. I have considered the apparent grounds of appeal, reviewed and reassessed the evidence adduced before the trial court, written or submission for and against the appeal, and I get the following as the core issues in the evidence in the case, which court has to determine whether or not the contradictory evidence was material, whether the prosecution failed to call key witnesses, whether or not the learned trial magistrate considered the apparent defense of alibi. Now, from the record on the issue of contradiction, it is a fact that there were contradictions in this case. The complainant PW1 initial report made to the police on 4th November 2018 is different from what she told the court. She told the police that she was given a lift by the apparent at around 3:30 p.m. while she was coming from Bulaju, heading to Burakibile to visit her mother. And that upon entering the apparent motor vehicle, she fainted, and after 2 hours regained her consciousness, finding herself around a borehole, feeling pain at her private parts. She stated that she went home, and since her parents were not around, waited until the next day when they came, and she told them what had happened. She was taken to hospital and treated. She stated that she went home since her parents were not around. This version of the allegation is also corroborated by information in the general outpatient record under the history and the physical examination. The complainant, in her testimony before the court, gave a different version of what had transpired. She told the court that on 3rd November 2018, 1:30 p.m., the apparent called her and invited her for revision in preparation for their KCSE, as she was a Form 4 student. She left the house and met the apparent on the way driving a probox. He entered and he drove to some private house next to the AP camp. There was a testimony that the parent committed the crime in the said house after stupefying her. The investigating officer in his testimony before the court admitted the contradictions in the initial report and made the latter development. It was his position that after investigation, he found out that the rape by the apparent had happened in a house and not in a probox, as he alleged. The manner of treating contradiction evidence in a case was stated in the Court of Appeal case of Mwanzia Musembi, where the court cited the case of Uganda. Quote, with regard to contradictions in prosecution case, the law is set in numerous authorities that the grave contradiction, unless satisfactorily explained, will usually but not necessarily lead to the evidence of witness being rejected. The court will ignore minor contradictions unless the court thinks that the point to deliberate and truthfulness, or if they do not affect the main substance of the prosecution, excludes the court. Additional Joseph Maina Mwangi case, criminal appeal number 73 of 93, the Court of Appeal is dealing with the question of discrepancies held court. The legal principles is that an appellate court, considering any alleged discrepancies and contradictions, should be guided by the fundamental question whether such discrepancies or inconsistencies or contradictions cause prejudice or miscarriage of justice is the apparent on both conviction and sentence, close the quote. In this case, the explanation given by the investigating officer for this said contradiction was that the complainant might have been confused or unconscious when she made the report on the following day. Therefore, the issue of complainant being confused or unconscious does not suffice in the circumstances. Additionally, the complainant, PW1, was accompanied by PW2 and 3 when she made the report to the police. Nothing of this sort was alluded to. Saying above established principles of the law on the effect of inconsistent discrepancies in this criminal trial, it is apparent to this court that this was the only material contradiction in this case, and that issue was where the rape incident occurred. The trial court, which had the opportunity to consider the demeanor of the witnesses, reaching a finding that the alleged rape incident occurred as narrated by the complainant court, adopted PW1 evidence in the court, which position was also adopted supported by PW8. If you the above, the trial court found that the contradictory evidence herein was not material. This view of the fact that the place, this is also in view of the fact that the place of incident was not being challenged by the defense, and the defense solely raised an issue as issue of alibi as the main line of defense. Be that as may, I find that the contradiction, though apparent, it would appear to be, it does not appear to be material to affect prosecution case, as a critical question was whether the complainant was raped or not, and by who. It's not affected. In this case, the complainant was clear in the allegation that the apparent was a culprit in both instances. On whether the prosecution failed to call key witnesses, the apparent contends that the prosecution in this case failed to call crucial witnesses, and therefore the court ought to have made an adverse inference of the same. He submitted that the prosecution deliberately failed to adduce evidence or call witnesses who would have established whether indeed there were any prior communication between the apparent and the complainant. This, they argue, happened despite the apparent having handed over his phone for forensic analysis, which report they submitted was deliberately not produced. The crucial witness in this regard, one Amos Kuria, who despite attending court was not called to give his evidence. He submitted that the failure to call the said witness was fatal to the prosecution case. I cited the case of Bukenya and others for the Republic. Section 143 of Evidence Act states, quote, no particular number of witnesses shall in absence of any provision or law to the contrary, be required to prove any fact. Julius Kalewa Mutunga case, Court of Appeal held, quote, as general principles of law, whether a witness should be called by the prosecution is a matter within their discretion. An appeal court will not interfere with the exercise of that discretion unless, for example, it is shown that the prosecution was influenced by some oblique motive, close the quote. In Bukenya case cited by the apparent, the counsel above, where, where the East African Court of Appeal held court, the prosecution must make available all witnesses necessary to establish the truth, even though their evidence may be inconsistent. The court has right and the duty to call any person whose evidence appears essential to for just decision of the case. Where the evidence called and theory is uh, adequate, the court may infer that the evidence of uncalled witness would have tended to be adverse to the prosecution. Therefore, the adverse inference should only be made by court if the evidence of the prosecution is not always very adequate. Accordingly, it will not be inferred where the evidence that is sufficient to prove a particular matter in issue or an entire case. The question that stands out in this case is whether the evidence of Kuria was material. The statement was allegedly concerning an analysis of the phone records of the appellant. It was meant to establish whether there was a communication between the appellant and PWN prior to the alleged rape victim incident. It would review the nature of the communication between appellant and PWN and give further credibility to the prosecution case. A number of issues arise in this regard. For instance, what was the nature of communication between the appellant and the complainant? Did the forensic analysis of the appellant phone point out an existing relationship with the complainant and the appellant? Is it a coincidence that the applicant phone could not be analyzed that the complainant phone could not be analyzed on the allegation that it fell in a toilet? Or is there a possibility that it was found out that there was no communication between the appellant and the complainant? These are crucial questions relevant in this case, at which to date stands unanswered. Assuming forensic analysis has established any frequent communication between the appellant and the complainant, the same would point out an existing relationship between the appellant and the complainant. Therefore, doubt would rise as to the issue of consent. The provision of Section 124 of the Evidence Act allows the court to convict the sole evidence of a victim if satisfied that the victim is being truthful. In this case, the truthfulness of the complainant here has been put in doubt. This is in view of the fact of her contradiction in the report she made to the police, the testimony she gave in court. This being the case, more cogent evidence, including forensic analysis of appellant phone, ought to have been produced in support of the prosecution case. The trial magistrate found that there was sufficient evidence implicating the appellant as the perpetrator of the offense. Failure to call a witness will only be fatal if the evidence tendered by the prosecution is insufficient to sustain a conviction, and that there was need to call the witness to fill gaps. In this case, there were gaps there were gaps to be filled by the evidence of the phone analysis, which were deliberately not available to court. In this case, there not being any corroboration of allegation of the rape by the complainant, conviction being only founded on a finding under Section 120 of the Act, which conviction in this court finds are safe. I find this ground of appeal has merit. On whether the learned magistrate consider the defense of alibi. In this case, the apparent defense was that of alibi. The apparent alleged that on 3rd November 2018, he was home, say for the time he attended mosque between 6 and 6:30 a.m. Being a Saturday, he alleged that he stayed indoors until 4:00 p.m. when, in the company of his wife, he attended Almadu Nursing Home for treatment as he was unwell. Thereafter, they passed by a shop and bought foodstuffs, left for home, and he never stepped out until the following day, 4th November 2018. DW2, his wife's testimony seems to corroborate this. Additionally, the evidence of DW3 also in his support of the apparent alibi, as DW3 stated that the apparent was home on 3rd November 2018 between 1 and 4:30 p.m. The apparent submitted that the trial court failed to investigate and consider his alibi. He submitted that the apparent, upon being arrested, raised the defense of alibi, which position they submit is corroborated by the evidence of PW2, who was arresting officer. PW told the court that he visited the hospital in the apparent, hospital the apparent allegedly had attended on the material day. But the apparent submit that no evidence of alleged investigation of alibi was adduced. submit the apparent alibi was further supported by testimony of DW2 3. The trial court on its judgment reached a finding that the apparent alibi was raised too late in the day and therefore the same cannot be believable, and it went ahead, ruled that the same does not displace the prosecution evidence. When the accused raises an alibi defense, it does not in any way mean that the honors of proof shift to him, but always remain the prosecution. All that fact needs to do, what needs to do is to analyze the entire evidence on record and determine whether or not the alibi raised casts any doubt in the prosecution case. The case of Mulinge versus Republic 2014 Kenya law report, court held state it is strict law that the burden of proving falsity, if at all, of an accused defense of alibi lies on the prosecution. Close the quote. When the defense of alibi is raised and trial at the trial and witness called by the defense, the prosecution will have the opportunity to rebut the same. Section 309 of Criminal Procedure Code states, quote, if the accused person adduces evidence in his defense introducing new matter, which the advocate for the prosecution could not, by the exercise of reasonable diligence, have foreseen, the court may allow the advocate for the prosecution to adduce evidence in the reply to rebut his close the quote. Case of Wadedeji versus State, 1971 1-0 England Road Report, page 75, it was held court. Failure by police to investigate and check the reliability of alibi would raise reasonable doubt in the mind of the tribunal and lead to the quashing of the conviction. Close the court. In this case, it is apparent that the prosecution were aware of the apparent alibi, which was raised at the time of arrest, as per the evidence of the investigation of the PWH, who in his evidence stated that he visited the hospital in which the parent had allegedly visited in the day of alleged rape incident, but did not find the record as the person in charge was not in. The way the alibi defense was handled by the investigation officer was casual. It seems the prosecution ignored the alibi, believing that they had strong evidence to displace the same, which position that the trial court considered and convicted the apparent. Therefore, it is my finding nonetheless that the apparent alibi was considered, though casually. In the case of Chebi versus Sewe versus the Republic 2003, the court expressly stated the suspicion may be strong, but this the suspicion may be strong, but this is a game with clear and settled rules of engagement. The prosecution must prove the case against the accused beyond reasonable doubt. Close the quote. It is clear from foregoing that the conviction of apparent hearing raises doubt. Putting the apparent of charges does not necessarily mean that he was innocent, but implies that the prosecution failed to prove their case beyond reasonable doubt. The upshot is that they find the appeal meritorious for the following reasons: allow the appeal, quash conviction, set aside sentence, and order the apparent to be released forthwith unless otherwise lawfully held. With some correction. So, umemaliza yake? Yeah, set aside, you'll be released, eh? Okay. So, can you explain yeah, I think I got it. So, there's some corrections to be done, but there is appeal tax. So, the next one is this one. Number? $24. Number 73. You able to get me? Yes, I mean, kusumbua kidogo. Get me the number. Yeah. Is it the one? Give me one, please. giving my judgment. So you got the file. Different. This is English. Susan, these are things might be having the other part. Then this one, maybe you can confirm your code. Which language? Somali. The appearance charge of offense of defilement contrary to section 8, section 1 and 2 of the Sexual Offence Act for defiling a boy aged 6 years was convicted and sentenced to what is referred to as mandatory sentence. He launched the appeal against that sentence and conviction. And meanwhile, he applied to be released on board. The court has read through his evidence as submitted by his advocate. The only issue court find is whether he has established the grounds for release on bail pending appeal. After going through what he has presented, the court finds that he has not established that he is entitled to be at this stage, and the court dismisses his application for board. And you'll be given a copy, a copy to be taken to him to see the reason why the court finds that he cannot be released on board at this moment. Understand? Yeah. The appeal will be heard when he's inside. That is the bottom line. So the farming values give the line. As he understood, that is the body is not be granted his life sentence. It will be heard when he's inside. Is this number, the number 73? Yeah. 73? Is it one of the 73? Yes. 73. Ibrahim yes. Okay. He was charged and convicted and sentenced to life imprisonment for offense of defilement. He lost the appeal on that first one, 2013, which was dismissed after full hearing in the High Court. He has now moved this court for resentencing, relying on the case of Muatetu. Sorry, sir. Is he hearing? Yeah. The prosecution does not oppose the application but urges court to refer the matter back to the lower court for mitigation and sentence. So the court must order that the sentence set aside, or the life sentence has been set aside, and the matter is referred back to Chief Magistrate Court Garissa for sentencing after mitigation. What does he want? Okay. The rainbow? So, is it on? Is it? Okay. The applicant was charged with offense of robbery, contrary to section 296. Isn't it Somali? Yusuf Musa, the rainbow. Lugha gani? So he was charged, convicted, and sentenced. He was sentenced to death. He appealed in the appeal case number 142 of 2013. Which, after it was heard, it was dismissed. He has now moved to this court for his sentence, relying on the case of Murwatetu. Relying on the case of Murwatetu. The prosecutor does not oppose the application. That the court now sets aside the death sentence and orders him to be taken back to the Chief Magistrate Court Garissa for sentencing after mitigation. Date watapeleka huko kwa sababu ya hii mambo ya
unaambiwa tutaletewa huko.
unajua saa hizo ndio sasa kuland We have taken it.
حسن عبد كولانت حسن عبد كولانت unaelewa lugha gani? Somali. Sawa, sikiza.
The applicant was the first accused in trial court, where he was convicted and sentenced to serve life imprisonment for defilement of age 6 years. He urged the criminal appeal number 74/2017, consolidated with the number 76/2015, which was after hearing was dismissed. He is now here for resentencing, relying on the Murateto case. The prosecution does not oppose. The sentence is therefore the life sentence is set aside and will be referred back to Magistrates Court, Chief Magistrates Court Garissa for sentence.
marka xukunkii cimri xirkii gaara loo dhigay waana maxaa lagu soo celiyey maxaa la amray maxkamastaada lagu celiyo gaaris oo xukun haddana lagu xukumo.
Umeelewa?
Ma fahamteen? Ma fahamteen?
But they don't have
Haye, waa bixi kartaa. Haye.
this Manda. I don't know how we are going to. Yes, there's a case here in the sun, which is coming for ruling, and which is likely to edit the case. I don't know whether we can agree about who can hold it. This Manda Mata, number 8 of 2015. Yeah, right, sorry. Anaitwa nani? Angalia hii mwingine. Yep.
Mutunga Mbidio na James Nguye.
Yeah.
Nani Mutunga Mbidio? Mutunga Mbidio ni nani? James Nguye. Awekeni mkono chini. Haya, msikize.
The accused person was charged with offense of murder contrary to section 203 and 204 of the Penal Code laws of Kenya. Particulars being that on 21st and 22nd of March 2015 at Kasten Market booth location Wingi, he murdered Zaun Ziu. The accused person pleaded not guilty and the matter went into full trial. The prosecution called 9 witnesses. None of the witnesses witnessed the killing of the deceased. The incident report reported between it was between first accused and a deceased who was at the bar. They were at the bar at market where PW2 Teresia Duku Lonzo separated them fighting. That is a accused one and the deceased. deceased,
na marehemu
and they were separated by Teresi and Duku.
na mliweza kuunganishwa na ndugu kilimo.
This was at 10:30 p.m.
Hiyo ilikuwa wakati siku
The two were drunk before quarreling and exchanging blows.
watu
She asked them to leave the bar, and they left at 11 p.m. and the bar was closed.
na akaweza kuwaomba
That bar was also witnessed by PW4 Richard Martin.
na hilo
In the morning next day, that is a PW received a call from one Joseph Mutisia.
siku iliyofuata moja Teresia aliweza kupokea Teresia aliweza kupokea simu kutoka Teresia
Who informed her that the deceased was found lying down, beaten.
na
She went to the scene and found him lying down with injuries and naked. There was crowd of people at the scene, and the deceased was still alive.
na ule marehemu alikuwa bado wako hai.
The police were called and they took the victim to hospital.
Polisi waliweza kuitwa na
He later died in hospital.
akaenda
She did not know who attacked the deceased after they left the bar. PW1 father of the deceased also learned via a call by his son that the deceased had been found lying beaten and naked.
baba ya marehemu
He proceeded to the scene together with his wife PW6. They saw him oozing blood from the mouth. The police came to the scene and took him to hospital. He died later as he underwent treatment in Mwenge Hospital. They did not know who had attacked and injured their son. PW3 stated that on the material night, while with PW5, he saw two accused persons between 1 a.m. and 2 a.m. by roadside, 100 meters from where the deceased was to be found injured. This witness did not see the deceased, and he could not connect the two with the attack of the deceased. PW7's Chengo Mati says that in the morning of 22nd March 2015 at 6 p.m., he found the deceased of the victim lying on the ground at the bus stage, groaning in pain. PWH was called by PW7, who told it never knew who attacked the accused, the deceased. PW8 was called by PW7, who told her of how he found the victim lying at bus stage, injured and naked.
Labda na aliye ambaye aliweza kueleza kwamba aliona huyu akiwa amelala pale basi, akiwa ameumizwa na hapo
She saw him at the scene and in a state where he was not breathing, but not he was breathing but not talking.
akaweza kwenda pale mahali kulifanyika na kuweza kumwona yule marehemu akiwa anaweza kutoa akiwa alikuwa na breathe lakini hakuwa anaongea.
PW9 was investigating officer who produced the postmortem, and he stated that the report of
Mshahidi wa tisa ambaye alikuwa mtumishi wa kesi aliweza kutoa tasmini na kuweza kusema kwamba
which was still held by the investigating officer. The court is called to determine that was the last witness who was called by prosecution, and the court, upon closure of the case, was called to rule whether there was a case to answer.
na ilikuwa ikiweza kuangalia kama kuna ambao kama ninyi wawili mnaweza kupatikana na kesi ya kuzibu.
The prosecution is bound to prove on prima facie basis that there is the ingredient of murder to the effect that the fact that the death occurred, that the same was caused by an unlawful act of accused persons, and that the same was exacted with the malice aforethought.
Na kiongozi wa mashtaka anatoa kwamba kuna kesi kama kuna mshahidi tosha wa kuweza kufanya pia
It's only at that stage the accused can be called to answer in defense.
hapo ndipo baada ya kiongozi wa mashtaka ndio mtaweza kuonyesha baada ya kupatikana na pia
As to the fact that the death occurred, the postmortem produced by consent proved that the accused had died of injuries of scalp hematoma with brain contusion due to
inaonekana kwamba
multiple
ile
blunt force trauma to the chest and head.
ile kwamba yule marehemu alikuwa na kichwa na akiwa na umu ambayo inaweza kudhuru brain yake kuweza kuingiza damu kuweza kuweka damu.
So the issue of the fact of death was proved beyond reasonable doubt that the deceased died.
Na kwamba waliweza kuongoza mashtaka aliweza kuonyesha kwamba huyu marehemu Wasua alikufa
The contest is as to who did inflict the injuries.
na kile ambacho
Thus, the entire prosecution case exonerates accused number 2.
kwa hiyo ushahidi wote
The only person who is mentioned as accused number 1, who was, according to PW2 and 3, he fought in the bar
na yule
before
mtu ambaye
both were
aliweza
separated.
kutajwa hapa ni na kwamba waliona yeye na mlalamishi wakiweza kupigana pale kwa bar na kuweza
The second accused and the deceased had a brief encounter where they exchanged blows before they were separated, and they went each on his way.
na kwamba
Maria.
na marehemu mimi na
No other evidence connects second accused after that encounter.
na hakuna jambo kufika na ile
PW3 and 5 narrate that they saw accused 1 and 2 at 1 and so they saw accused 1 and 2 at 1 a.m. I think it was 1 a.m. 100 meters from the scene.
mita 100 kutoka ile mahali ya kitendo kilifanyika
Where the victim was to be found in the morning. However, the PW 3 and 5 did not see the victim at that moment and time. Neither neither did he connect the attack to their presence. At least he saw them that hour. The exchange of accused one and the victim at the bar did not inflict the injuries disclosed in the postmortem. They were separated without any notable injuries. The injuries in the postmortem were inflicted elsewhere, not in the course of the exchange of the blows. The circumstantial evidence does not put the two accused persons in the circumstances to the point that the two as the perpetrators of the crime charged. The fight of the two is stated to be a common bar brawl arising between two drunkards with no motive disclosed. After separation, the two went separately. This was between 10:30 and 11 a.m. Anybody could have attacked the victim thereafter. The court finds that there is no prima facie case established to warrant the two accused persons to tender their defense. Therefore, they are acquitted and released forthwith unless otherwise lawfully held. Umeelewa?
Naelewa. Naachiliwa. Sawa, unaweza enda.
This was by number 17 and 14. Nyaga. Nyaga? Nyaga. Who is this? Oh, sorry.
David Mwendwa Mulwa. David Mwendwa Mulwa, unaelewa Kiswahili? Unaelewa Kiswahili? Unaelewa Kiswahili?
Okay, this is the accused David Mwendo Mura was charged with the murder contract to section 203 of Penal Code,
David Mwendo Mulo akiwa na shtaka la kuua kinyume na sheria
particulars being that on 19th January 2014 at Buba, Bubu, Bubu
na maelezo ni ya
location
kwamba
Mwingi
mnamo
East
tarehe
Kitui.
mnamo tarehe 19 mwezi wa kwanza tukiwa huko Nguvu subdistrict Kitui County iliweza kuua John Mwinyi Mtua
And
kwa shtaka la
Kavata.
kwanza na kuweza kuua kwa shtaka la pili Kavata Mwinyi.
He pleaded not guilty and matter went for trial.
Aliweza kukataa hilo shtaka na kesi kwa trial.
After close of prosecution case, the accused was put on his defense where he tendered and sworn defense and got no witnesses.
Baada ya baada ya upande wa kupenda kutetea na kuweza kujitetea bila kuapishwa na bila kuitwa zaidi.
The prosecution case is that PW1 testified that on 20 January 2014 at 7 a.m. while taking children to school in his neighbor, with his neighbor, his neighbor Musia came to his house and told him that the accused David Murwa Akabisi had taken goats to the market. The goats belonged to the Muilo, the first deceased herein. And that the said Muilo wife, Kavata, had, he also said that the said Muilo, the wife of Muilo, Kavata, had broken leg, and this he was told at night of 19th January 2004. That they, when accused sold the goods, that is now the Muilo, this Musia was telling the PW1 that when accused sold the goods, the accused was to bring the money to the first deceased so that Kavata could be taken to hospital. Mwilu was a young brother of a witness father. Young brother. Mwilu was a young brother of witness, that is the PW1's father. Accused lived with the deceased persons in their premises. When he got their first aid information, he thought accused was sent by the deceased Willow to go and sell the goats. Not when the PWN got that information. After taking children to school, he was called by one Kasioka Musia, who told him to go to home of Miro, as he had seen things he could not understand. He was called by him. Where at the scene, he proceeded to the scene, and where at the scene, home of Miro, he saw blood stains in the kitchen, outside the kitchen, the poles of the house. And poles of the house. Yes, there were also spades which were bland stains. Yes, a spade. There was also a spade which was bland stains. There was also a chair with the bloody stains and a stick. The assistant chief was informed via telephone and he came to the scene. Thereof, he called the police to come to the scene also. He mobilized people to excavate the toilet, and two bodies of the deceased were retrieved from the pit latrine. The toilet, which is a latrine. They were collected by police after photographing and also at the exhibit being collected. The witness, the witness witnessed the postmortem of two two deceased persons being conducted. Accused was brought up. Accused was the witness also stated that the accused was brought up and educated by the deceased persons. No, he was brought up. He was educated by the deceased person. He also said that the accused was arrested later in Garissa, and the witnesses saw him at the Ukasi police station. PW2 John Kamau, Assistant Chief, stated that on 20 January 2014 at midday, he received call from Okasioka, a neighbor of deceased, asking him to go to the home, Mwilo. So he went to the scene and also saw the items which were blood stained. We also saw the pit latrine which was covered with soil. One old man, Muthioto, told him that the previous night, the accused told him that Kavata broke legs, and Mwiro told him to go sell goods and bring him the money. And the incidents also say that while at the scene, he called the OCS Ukasi. The police came to the scene, did photographing, and collected the body. PW Dorcas Munyoki, a neighbor to the deceased, who was a neighbor, narrated, and in written to him, stating that accused lived with the deceased couple as a Kavata lost her only child, and she asked her sister to allow her to live with the accused. On 20 January 2014, or in Garissa, the witness received the report of death of the couple. She saw accused David in Garissa. When the David saw her, he ran away. It is it is him who ran away when he saw her. No, when he saw the witness, that is Dorcas Munyoki, he ran away. Now, on 10th September 2014, at Mororo, Risa, she saw him at the restaurant as he called police who arrested him. At the police station, accused kneeled down before her and started narrating what he had done. He said he committed the offense because his aunt Kavata prevented him from selling his own goods. He said he committed the offense to be able to sell the goods.
kumweleza ya kwamba ulikuwa umefanya hicho kitendo na kwamba ulikuwa umefanya hicho kitendo kwa sababu anti yako Kavata alikuwa amekuzuia kuuza nguvu zako na ukiweza kufanya hicho kitendo ndio uweze kuenda kuuza hizo nguvu.
EW4 Hilary Reagon testified that on 20 January 2014, he received reports at 14:30 p.m. that two people had been killed. He got it from the OCS Ukasi police station. He entered same in the OB and proceeded to the scene. He proceeded to the scene together with the OCS and other officers. They supervised the opening of the latrine and retrieving of the two bodies, collected the exhibit and the body and took it to the morgue. And the exhibits, which were they got information that the accused left at 4 a.m. with the goods of the deceased to sell them. Later, accused was arrested in Garissa and charged with offense. PW5 Bernard Kemani, police of Constable Kas Police Station, produced the postmortem by consent as exhibit number 4. The prosecution closed his case and the accused was put on his defense. He gave unsworn evidence and called no witnesses. He denied killing the two accused persons. He said on 19 January 2014, the death of the two occurred. He was in Garissa. Wanted him for police to be arrested in Garissa. The parties, he closed the case and the parties agreed to put written submission, but at the time of preparing this judgment and to date, none of the parties has filed their submissions. The court prepared the judgment without the benefit of the submissions by both sides. Right judgment without the. Now, under Section 203 of the Penal Code, the law states that in a person who malice aforethought causes the death of another person by a lawful act or omission is guilty of murder. Now, in the case of Joseph Kimani Njau for the Republic 2014 E-Kenya report, the Court of Appeal heard court or the criminal trials who the act reviews that the act and the motive or the mens rea are required for the offense charge and they must be proved by the prosecution beyond reasonable doubt. The trial court is under duty to ensure that before any conviction is entered, both the acts and mens rea actus reus and mens rea have been proved beyond reasonable doubt.
na koti inasemekana ya kwamba lazima kiongozi wa mashtaka aweze kuonyesha ama aweze kutoa ushahidi tosha ndio aweze kufungwa,
There is no contest that the death of two accused persons died.
na hakuna pingamizi ya kwamba hawa watu wanaweza kufa.
PW1, 2, 3, and 4 witnessed the retrieval of the bodies from the latrine. Postmortem report confirms the deceased persons died due to multiple injuries to the head with sharp objects.
Na postmortem iliweza kusema ya kwamba hawa watu walikuwa wamepigwa kwa sababu ya wao kupigwa kwa majeraha kwa kichwa na ilikuwa inaweza kusababishwa na kitu ambayo ilikuwa chafu. Na walikuwa wameweza kutolewa kutoka kwa picha za chini kwa shimo la
Thus, the fact of death was proved. As to whether the accused is responsible for the said injuries, which caused the death, the available evidence is circumstantial evidence.
na
The court has,
alikuwa amekufa.
the court has relied on the several authorities on circumstantial evidence, and
Na koti pia zaidi ya kabla
the court has looked at the evidence that the accused used to live with the two deceased persons as he was brought up and educated by Kafata, one of the deceased, who was an aunt and was given accused while he was a child by her sister.
na ya kwamba kwamba kuwa funzo ambayo na kwamba ilikuwa kwa anti yake na alikuwa tayari na sister yake tangu ukiwa mdogo.
On 19th January 2014, Modioto saw accused with the ghosts of Mwiru, the deceased, taking them to the market to sell and stating that he was going to sell them under owner's instruction and bring him money to take the wife who had broken legs to hospital.
Mnamo tarehe 19 pale na kwamba amepeleka mbuzi za mwili kwenda kuziuza na akasema ya kwamba alikuwa anaziuza kwa sababu mwenyewe alikuwa amekueleza mwende uziuze aweze kumletea pesa ndo aweze kutibu yake kabla ndani.
PW2 informed PW1 of the fact that the accused did not challenge that piece of, the PW2 informed PW1 of the same fact. The accused did not challenge the fact piece of evidence by PW2.
Na kwamba
The accused disappeared from that date to Garissa until the day he was arrested on 10th September 2014, which was a span of about 9 months.
na wewe ukaweza kutoroka na ukaweza kushikwa baadaye saa ambayo
When arrested, he told PW3 that he committed the crime as the aunt Kavata disease was preventing him from selling his own goods.
na unaweza kuenda mshahidi wa na anti yako Kamata ambayo ni marehemu alikuwa anatafuta zako
The disappearance from 19th January 2014 to 10th September 2015 of about 9 months, but the fact that he admitted to PW3 after arrest that he committed crime because deceased Kavata was preventing him from selling goods convinces the court beyond reasonable doubt that he inflicted the injuries to the deceased persons which caused death.
na wewe baada ya kutoroka na kisha baada ya kukubali na kueleza kitendo inaonyesha koti ya kwamba wewe ambayo umefanya hicho.
He never rebutted the evidence of by PW2 that he was going to sell the goods on 19th January 2015.
Na hofu kama
The court therefore holds that the second belief that the person who caused the injuries is the accused is proved beyond reasonable doubt. On whether the malice aforethought was proved, the court has noted that the injuries were very serious, grievous harm by any standard. The same was inflicted with aim of either inflicting a grievous harm or cause death.
na kwamba ilikuwa inaweza kufikia marehemu inaonekana kama ilikuwa ya kumuua na ilikuwa kubwa na ilikuwa na nia ya kuweza kifo ama kujeruhi zaidi.
The infliction of the noted injuries and subsequent burying the deceased persons in the pit latrine was definitely absolutely to absolutely cause death of the two deceased persons.
Na
Thus, the
kisa
malice aforethought is proved beyond
na
reasonable doubt.
kisa kwenye shimo la choo na kwamba
Thus, the court holds that the murder charges have been proved beyond reasonable doubt, and he is convicted of murder offense accordingly.
na koti kuwa umeonyeshwa na kupatikana pia umeweza kuhukumiwa na hilo jambo la kuua.
What do we say about that now? Stand you for. Yes. Yes. And also the report will also be done the same time. That's after you're able to access your client in prisons or otherwise. In prisons or otherwise. Yeah, because now, Mr. But I don't know whether I even noted. You may have to check the file. For prosecution, you not the present. I think I've been putting the advocate. Magero had been omitted, but you added Magero for the prosecution. Is Magero? Okay. Yes. So he's going to remain in custody, awaiting the date for mitigation and sentence. So it to be communicated.
Utakaa huko ndani, wakili wako ataelezwa, atakuja akutetee na utaweza kuelezwa zaidi na wakili wako. Sawa?
Whatever is Muse.
Mzee Kiema,
This is Mr. Nyaga.
Mzee Kiema, unaelewa lugha gani? Eh? Kikamba? Unataka Kikamba? Sawa.
You have no keys, right? There's a Mkamba nearby.
Unaelewa vizuri? Unasikia vizuri? Haya. Ongea kwa sauti. Toa point.
Number 11. Who was next? That's the one, a source of Nyaga. Nyaga. So, not what is your name? Spell it. L-A-I, lies. Okay. Okay. So, he was, Mose Kiema was charged with the offense of murder compared to section 203 and 204. It has been that on 2nd February 2015 at Karithini village, Mwasuna Nguni Mwingi, he murdered Faith Moyati Zomo. The accused pleaded not guilty and matter went to full trial. And he was told killing Kavida. He did not mention whom he is accused of killing. Sorry, you tell him he was accused of murdering Faith. Now, the prosecution called witnesses and closed his case, and the accused was put on his defense, and he gave his defense. The first one was Kiema Ngwamba, father of the accused, his own father. No, his father, who told the court that on 22nd February 2015 at 8 p.m. he had been told goats of Muyavi having gone to accuse lad and damaged his crops. He was told of the goods. No, the Kema Kwamba had been told that the goods had gone to his land. They damaged the crops. The accused was also told of the same fact of the goods having entered his land and destroyed the crops. His father met accused coming from Said Muyadi's house. The accused told him that Muyadi abused him and that he is proceeding to his house. Is proceeding to her house with the bows and arrows. He proceeded to the house of that lady. He tried to beat that lady using a bow, but his father held him, his hand. Then the accused pierced the lady right side of the chest with the two arrows he was holding on the left side of the chest. Fell down. Right. He pierced, not shooting. He just stabbed her. And then he pulled them out. Then she fell down and died. The police who were later called came and collected the body and take the body to the mortuary. There was family meeting later, and the witness, that is the father of the accused, paid compensation in monies to the deceased family. The witness identified the two arrows used in the as murder weapons. The second witness was Lena Mawia. Sorry. The second witness was Lena Mawia Bovi, who testified that accused went to her house following Faith Muyavi. The Faith entered her house and she saw accused come carrying bow. He told Faith, "Let me go, I will come back." The witness heard voices of accused and his father coming to her home from the road. The witness told the deceased to leave her homestead, but the deceased said since the accused is with his father, that is the old man coming, she would stay there. The accused person arrived first and stood 7 paces away. Ida stood near that is the father, stood near the deceased and asked deceased what matter he had with accused. As accused had told him she had insulted him. She denied insulting him. The accused started making a noise. The witness told the accused to explain the issue to his father. No, Leonard told the accused to explain to his father. The accused moved towards deceased carrying bow on one hand and arrows on the other. When she raised the bow, when he raised the bow to hit the deceased, when the accused raised the bow to hit the deceased, his father held him by hand. Then the accused stabbed Faith with arrows on the lower side of the chest, and then he pulled them and went away. Faith fell down. Everyone trying to help her. The witness screamed, and the police were called later. They came to the scene, photographed, and took the body away. PW3 watchman on Zoya, on Zoya, Moses Mugui Zoa, also saw the accused at the scene. The same evidence is also the witness number 4. No, the another also witness number 4, that is Mutinda Musyoki Kituli, who also learned of the material night of the murder of the deceased. Further, there was also witness number 5, Mulungia, the husband of the deceased, who witnessed the postmortem being conducted on 2nd March at Migwani. That is Muliungi, who was the husband to the deceased. Who was the husband to the deceased. Now, there was also Peter Zoki Wambua, assistant chief, who was also informed of the killing of the deceased and who called the police from the Guli police station. There is also PW7, Corporal Geoffrey Limo, who was also informed of the incident and went to the scene with other officers and took the photographs and collected the body to the mortuary. He said then the accused, after that witness, sorry, they collect the body and took to the mortuary. And he said that when he talked to the accused said that He killed Faith in Zoma.
nawe ne
He volunteered to show police where he hid the murder weapons, the two arrows, and both were taken by the police and taken for to the government chemistry for examination. They were blood stained. The accused was arrested and later charged. PWH produced the post-mortem report by consent of both sides. The prosecution case was closed at that stage and accused was put on his defense. He gave an sworn statement and called no witness. He gave an sworn and called no witness. He denied killing, but said he was told by his wife the deceased was attacked and killed by other people. Now, the duty of this court is to look at the evidence and analyze and to see whether the prosecution proved the case beyond reasonable doubt. There is no doubt that the death, because of the fact that the death occurred is not denied, and the postmortem produced by consent confirms that she was killed by injuries caused by sharp objects. The court finds that it was proved beyond reasonable doubt that the death was proved occurred. As to whether the injuries which caused death were inflicted by the accused, PW1 and 2 witnessed the quarrel between the accused and the deceased before accused pierced her with the two arrows in their presence. And his excuse was that she had insulted him. The accused defense is that the deceased was killed by other people. Of course, that is mere denial because his father, whom he doesn't say whether he had a grudge against him, witnessed his own son, the accused, uh, inflicting the injuries to the deceased person. Thus, the court holds that the unlawful act of inflicting injuries which caused death was perpetrated by the accused. As to whether he had malice in inflicting the injuries, the court finds that observes that the piercing of the deceased with two arrows at the lower part of the chest, then pulling them out, was so brutal, vicious, and very painful, and caused death within a short span of time at the scene of the crime. She died instantly. That injuries caused grievous harm, which shows that he had malice. PWN tried to stop the accused from inflicting injuries, but in vain. The accused has failed to justify the act of injuring the deceased, and thus the court finds that he is guilty of murder and is hereby convicted of offense of murder. He will be sentenced after mitigation. Mm. So accused to remain in custody, you'll be informed the date for mitigation and sentence. Okay, can call the other one. The other, Abdrazak. Okay, sawa sawa. The next one is John Mulu Monuve. John Mulu Monuve. Maybe you got the same witness, the same interpreter Monuve. Yeah, maybe quite. You will require the same witness, huh? Monuve. But you can ask him whether he understands Kiswahili.
Unaelewa Kiswahili Kipamba? Unataka kusomea na lugha gani? Kipamba?
Tell me Kiswahili. Which one? Is it? Ask him. Muulize ni lugha gani ataelewa.
Habari yako? Habari yako? Unasikia lugha gani? Eh? Sio unasikia
Kiswahili. This is isa Somiaga.
Angalia kompyuta tu, angalia chini. Na vizuri.
Okay. The accused was charged with the murder contrary to section 2 and 4 Penal Code, particulars being that on 23rd August 2014 at Twende area, Kiangati, Kivindu, Mwengi East, Kitui murdered Mwandikwa Kitheka.
Unashtakiwa na kuua kwamba mnamo tarehe 23 uliweza kumuua Mwandikwa Kitheka.
He pleaded not guilty and the matter went to full hearing. The prosecution closed the case. The postmortem was produced by the investigation by consent of both parties. The accused was put on his defense and entered his defense without calling any witnesses.
Na kwamba likataja sasa na kusimika kutolewa na kesi na ushahidi utaweza kutolewa na mashahidi.
Now, the first witness was David Mwani, Assistant Chief, who testified that on 23rd August 2014, he had arrived in Nguli Shopping Center. He met huge crowd. One of the young men, Kimwele Ruto, told him they got the accused who had killed the deceased.
David Mwani ambaye ni chifu baada ya mwezi aliweza kutoa ushahidi na kusema kwamba mnamo tarehe 23 mwezi wa 8 aliweza kufika pale na kijana mdogo Kimwele Ruto ambaye aliweza kueleza kwamba
Yeah, they were holding accused because they wanted to ban the accused. He asked the accused why people wanted to ban him, and he said because he had killed the deceased. So he said the witness thus phoned the chief of the area, informing them that the deceased was killed. Chief came and they called the police. Sorry, he came and they called the police from the Guni police station. Police. He called police from Guni police station. He took the accused to AP camp where he had spent the night, and the police collected him the next day. At the station, the police also, the accused also is said to have said that he had killed the deceased. Then he was talking things that they could not understand. Then the witness said that he also went back to the scene. The witness who was testifying, that is PW. PW2 Benjamin Kikane, a village elder, testified that he knew the deceased as he used to see him. No, the deceased. He knew the deceased. The deceased was a traditional medicine man, and he was a neighbor to accused. He stated that on 23rd August 2014, while repairing his fence together with his children, the accused came at 11:30 a.m. They worked up to 1 p.m. when they went for lunch, and then they left for Kanyonyo town till 6 p.m. Next day, he got call from his brother with information that the people got dead body near the river when they went to fetch water. No, him, the witness, where they fetch water and found the dead body. The witness informed his chief about it, and they went to the scene and called the police, who came and collected the body. The witness did not know the deceased by then. PW3 Robert Mulwa Kivika stated that on 24th August 24, they saw he was fencing with his brothers at 7 p.m. just past others. Accused killer. Accused past at 8 supper. Left. After 3 days, police came with the accused and they went to the scene of crime. The accused explained how he met the deceased, who said the deceased told him that he was a kind of a boy he bewitches. The accused explained how he met the deceased. amekoroga.
Gabaya ambaye alikoroga.
He said the deceased said he bewitched him to drop from the school. Accused said he snatched the stick, he snatched the stick deceased had carried, and they stepped on his stepped on his chest,
Na wakasema
and he died.
marehemu akaweza kukufa.
The deceased paraphernalia sticks were at the scene.
Hiyo ilikuwa
All these the things of these witch
hiyo vitu
and the paraphernalia were found at
vilikuwa
the
pale
scene.
kwa mahali kitendo kilifanyika.
They were taken to the police station
Tuliweza
together with the
kupelekwa
accused,
pale
and
ule ushahidi ambao ulikuwa hapo,
he was locked up where
waliweza
he
kuwekwa ndani
recorded his
na
statement.
wakaweza kuandika.
PW4 Alice Ndiga, mother of the accused, testified that she didn't know accused was arrested.
Ushahidi wa nne ambao ulikuwa Alice Ndivyo ambao mama yako aliweza kusema kwamba
She learned that there was a person who had been killed.
alijua kwamba mtu ambaye
Her son told her that he didn't know about the killing. She told, she told her husband about the arrest of the son and the allegations. And the accused told him about it at the police station. The father of the accused paid compensation to the family of the deceased. He, he went with the other people to pay compensation, and compensation they took and they took male and female hands of cattle. Male and female hands of cattle. He negotiated for compensation when he heard his son was arrested for killing deceased. So they agreed about the compensation for the killing of the deceased. He said the accused had mental illness such that he could strip and go nude. The bush, and her firstborn accompanied her to pay compensation. PW7 IO testified and produced postmortem. Yes, both sides agreed that it be produced by consent. The postmortem showed injuries of the deceased to be temporal region decomposed scar fracture. The cause of death was stated to be severe hand injuries. There you also see that they visited the scene and the accused confessed of killing of the deceased. The prosecution closed their case, and on the ruling, the accused was found had a case to answer. With on defense, he gave and sworn statement. And he never called any witness.
na ukiwa
He just said that he never committed the crime. The parties opted to submit, not to submit, but relied on evidence on record. The court finds that the occurrence of the death is not contested. Both sides agreed that the deceased died and the body was seen by all sides. Postmortem report showed severe injuries inflicted, and the cause of death was reported to be severe hand injuries.
na upande wa koti hakuna mtu ambaye alikuwa anafanyika na ya kwamba postmortem ilikuwa imesema ya kwamba kifo kilikuwa ya jeraha ambazo zilikuwa zimefanyika
As to whether the death was caused by a lawful act of accused, the accused was not seen killing the deceased. The only fact which implicates him is his statement
na kwamba hakuna mtu ambaye alikuwa marehemu, lakini kile ambacho yani tunakupinga ni
the crowd which arrested him and PWN all heard him admit that he killed the deceased. PW3 had at the scene of the crime accused explained to the police how he killed the deceased. The accused said that the deceased said he bewitched accused to drop from school. Thus, accused snatched the stick of the deceased. He carried, hit him on the head, and then stepped on his chest, and thus he died. At the police station, the accused admitted killing the deceased. When his father talked to him, he explained what happened, prompting his father filed a PW for testimony to negotiate payment for compensation of male and female hands of cattle, which was paid. All that evidence was not charged by defense, either in cross-examination or during the defense hearing. The accused only stated in his own statement that he denied the charge. Thus, the court finds the illegal act which caused death of the deceased were committed by the accused, and that the three ingredients of murder having been established beyond reasonable doubt, the accused is found guilty and convicted of murder accordingly. So this one also the same. So tell him you'll be informed of the mitigation date after the court operations resume.
Koti unaweza kuelezwa ile tarehe ambayo uweze kufikia, uweze kusoma majibu yako ndio uweze kupewa kifungo chako. Uweza kueleza kifungo chako. sawa. Baada ya koti ziweze kurudi sawa, utaweza kueleza kutoa malilio yako kuambiwa hatua ama kifungo. Haya, unaweza toka.
Abdullahi Barisa.
Abdiharam Barisa. Lugha gani? Hausikiki vizuri, ongea kwa sauti. Karibia kompyuta. Lugha gani? Kiswahili Sawa.
This was
Kiswahili. Sawa, sikiza hukumu lako.
Mr. Nyala still. The accused was does he understand English? Which is Kiswahili? The accused was child offense of man contrary to section 2 of the Penal Code, particulars being that on 16th June 2014 at the Rime village, Dura Tana sub-county, Tana River, murdered Twaha Abdallah Ismail. Yeah, matter went into trial. The prosecution called 7 witnesses. PW1 Aisha Jare's sister to accused testified that while at the break in school at 11 a.m., a bell rang as he saw Twaha Abdara, the deceased, hearing together with Ibrahim, both and the 8 pupils, take their bicycle and rode out the school compound, and others followed. Thereafter, shortly she heard people making noise and ran towards the school. The shouts and the noises were saying brother to Aisha had stabbed a pupil. Her brother came to school, but he did not know why he came there. He said they were saying that her brother, that is the accused, had stabbed a pupil. The injured people was taken to hospital, and at 1 p.m. the witness heard that people died. The witness learned that the reason for fight was because the deceased Toha was her boyfriend. PW2 had also testified to the fact that there was an affair between Aisha and the deceased. No, the pupil and the Aisha were the people who died, the deceased and the Aisha were having an affair.
huyo walikuwa na
Uhusiano wa
uhusiano
kimapenzi.
wa kimapenzi.
He said it was he said it was said the witness did not want the two. So the accused supposed to be they actually did not want the two to have to love each other. Now PW2 said he looked for PW1 and sorry he watched the PW1. Sorry, he saw the fight. Sorry, of the two people. They was sorry. He looked at for PW1 and they fought over it. They were sent to call the parents over it. PW3 chairman of the school was at school as pupils had fought. On 16th June 2016, he learned that the girls fought over a boy Toha, the deceased, and that boy had died. He tested that while in school he heard people screaming wakisema anamfuata, and when he came out he saw Abdul Rahman, that is accused, chasing Toha, the deceased. They followed them and found Toha writhing in pain, saying he had died. He was taken to hospital and he died on arrival. PW4 was told about the stabbing of the deceased by one father of the accused, and was told the reason of attack was because of love issue involving accused. Uh, so it's supposed to be this deceased and his accused sister. PW5 Ibrahim Hassan testified that on 16th June 2014 at 11:30 a.m. was with Twaha deceased. We were from school and both with the deceased rode a bicycle. As they were proceeding home, the accused followed them and whistled. He was on foot. The witness, that is Ibrahim Hassan, jumped off the bicycle and walked towards the school. He saw a PW2. Then the accused was near house, so it was near house in a villa. This area. Accused met the deceased, and the fight ensued. he met the deceased and the fight. The deceased struggled and freed himself and he started running away. The accused took a deceased bicycle and followed the deceased. They met at the open field, which could be seen from far. The accused, on reaching where the deceased was, he left the bicycle and chased the deceased on foot. Then the deceased then turned and went to pick the bicycle. The accused held him from the back to wrestle him. The fight ensued. They started fighting. When the accused wrestled the deceased down, he abandoned the bicycle and the two started a fist fight. Then the deceased ran and fell down. When the witness arrived, when the witness PW5 arrived, he, not, he noticed intestines protruding out. The deceased laid down bleeding profusely. He gathered and they took him and placed him under a tree. He was later uh, taken to hospital but died on the way. When the witness arrived at the scene, he saw the accused lying down, intestines protruding out, while the accused was at the scene holding or carrying his knife. The accused then put the knife to his shoulder and escaped. PW6 was accused uncle. He testified that on the 16th. On 16th June 2014 at 12 noon, PW2 came to him to seek transport assistance to transport young man who had intestines injuries. The person who was injured was Toha. He told him he was stabbed by Abdullahi Barissa, and they went together to the scene and found the young man and took him to hospital, but he died on the way. PW7 investigated the case and later accused was charged with the offense. The court was called to make a ruling on whether he had a case to answer, and the case was, was found to have a case to answer and was put on his defense. He gave sworn evidence but did not call any witness. The defense stated that it would not submit, but rely on the record. The prosecution submitted that all the ingredients of murder were established by 7 witnesses. The prosecution was duty bound to prove murder by proving the ingredients that the death occurred, that the cause of the injuries which occasioned the death were caused by the accused, and that it was done with malice aforethought.
na koti kulikuwa na huyu ndio aliweza kufanya kwa kusudia kuweza kumuua yule.
It is not denied, no contested that the accused was it is not denied, no contested that the accused injured the deceased with a knife. PW5 witnessed the incident of accused starting fight and pursuing the deceased until the police lied down with the intestines protruding when bleeding profusely. Accused was standing by the deceased holding a knife when he escaped and left BW1 and deceased at the scene. PWC2 also saw accused chase the deceased, thus the death of the deceased was thus proved to have occurred. SPW1, 3, and 6 on narrated that the deceased died on the way to hospital. The injuries is no doubt which were inflicted by the accused was serious, and they are the ones which caused the death. The By stabbing the deceased the knife to the extent that the intestines came out, the accused had malice to cause grievous harm or death, and he has to cause harm or grievous harm or death. In his defense, he has not justified the act of injury. However, the prosecution did not produce post-mortem reports. No evidence was lent to rule out natural causes as the reason for the person's death. In the case of Dongo vs. Republic 1985, Kenya Law Report 487, the Court of Appeal held, quote, where the body is available and the body has been examined, post-mortem report must be produced. The federal court having informed the prosecution that the normal and straightforward means of seeking to prove the cause of death is by regularly producing the post-mortem examination report, as a result of which medical officer who performs post-mortem report is cross-examined. In the case of Chengo Kalama, relying on the case of Dongo, held that Court of Appeal, the position then appears to be that, save in very exceptional circumstances, this is stated above, it is absolutely necessary that the death and the cause thereof be proved beyond reasonable doubt, and that can only be achieved by production of medical evidence, and in particular, post-mortem examination report of the deceased. The extent that the same was not done in the case, though available, death and its cause was therefore not proved beyond reasonable doubt. According to the judge, error did convict the apparent, close the quote. So in short, that the post-mortem report is said to be necessary to be produced to prove death. Cause of death. Also, the case of Angote held the same as a republic. Now, I'm of course aware of the decision of Dorocas, Chebet, Ketel, and another circumstances in this case are, however, distinguishable from those other cases. In light of the above decision, the court held that the prosecution did not prove the case of murder beyond reasonable doubt. I'm however satisfied that instant case, there is evidence to prove beyond reasonable doubt that the accused person occasioned the deceased grievous harm. The evidence of PW5 witnessed the fight between the accused and the deceased person. And in the deceased, when the deceased was stabbed with a knife by the accused, then accused escaped with a knife used to attack the deceased. So the deceased intestine oozing out as he was profusely bleeding. He knew the accused person, and it was in the broad daylight. In Dungu versus Republic case, Arya mentioned the court appeal recognized that even where the accused is found not guilty in murder case, he can be convicted on a lesser offense, on a lesser cognate offense. Thus, I find the accused person guilty of grievous harm contrary to Section 234 of the Penal Code and convict him accordingly, so he'll be sentenced after mitigation.
Itaweza kupewa kifungo lako au kuweza kuelezwa itakuwa kifungo ni miaka ngapi baada ya wewe kuweza kutokea, na hiyo utaweza kueleza na afisa wa prison ama court utaweza kuwaeleza utakuja tarehe gani kujitetea baada ya kuweza kurudi vizuri baada ya hili janga la corona kuisha. Umeelewa? Nasema nini?
Yes.
Unasema nini? Utakuja kujitetea baada utakuja kufanya nini? Utakuja kukusanya madilio yako ndio uweze kupewa fungo kwa miaka ngapi ama fungo lako. Mpaka na hatia la kupiga na kutia jeraha mwilini la kudumu, bali si la kuua. Sawa.
Mr. Magero, I hope you have understood why it has done that you did. Absence of the cosmetics, unless it's a no case like where somebody is decapitated. Usually we put the grievous harm if injuries will show like that one. So he died because of banana cause. But postmortem could have ruled out absolutely that it was only that injury caused the death. That one there was no postmortem. So you can't let somebody know that. Yes, I have seen a recent study they've been using that as well. This one is Abdi
Omar Ali.
Ataiko? Au kamiti. Okay,
Lakani Mohamed Nugu. Tayarisha Abdi Shukri Bure.
Fusca. Language, which language is it? Is it a Somali? Ni majina. Is it a Somali?
Daktari Mohamed Muguu inaitwa Somali. Which lugha gani? Somali au Swahili? Swahili.
The Africans was convicted.
Sikiza.
The African was convicted and sentenced to death on offense of attempted robbery contract to Section 297(2) of the Penal Code, criminal case 251 of 2012 at Hola, ya pili the High Court.
Unaweza kushtakiwa na shtaka la kujaribu kuiba
Kwa mabavu.
na ukaweza kufungwa na kifungo cha kifo.
He appealed and he was dismissed. He did not appeal. He has applied this court for resentencing in line of the case, relying on the case of Murateto. The applicant has invoked the principles of law and thus seeks the sentencing. The prosecution does not oppose the application, as the court orders that the death sentence is set aside and the accused will be taken to Hola Court, where he was convicted and sentenced for sentencing after mitigation.
Na utaweza kupelekwa Hola Court. Koti limeweza kuweka kando na limeweza kufikiria mbali ile kifungo cha kifo na linaamrisha uweze kuenda Hola Court na uweze kufungwa tena, uweze kupewa kifungo kingine tena baada ya kupatiana maneno yako.
Askimweli ya dafu.
Umeelewa? Unaelewa sio? Unataka kusema nini? Unataka kusema nini? Ongea. Na watu saa hii wamepewa beti karibu na wamepewa karibu na katano
Atabia koti.
na wamepelekwa loko. Sasa mimi nilikuwa nataka
kwa hiyo koti.
Sawa, basi unaeleza hiyo prison na kuweza kufuatilia huko Hola ndio uweze kupelekwa. Sawa.
There's one here. I have a drug here. He's trying to extract it. Here is number one. Sukure.
Abdi Shukuru Gure. Shukuru Gure. Unaelewa lugha gani? Swahili.
The accused was charged the robbery. Yes, the accused was charged the robbery with the violence under Section 296 of Section 2 Code. And in count 2, he attempted robbery under Section 297 of Section 2 Penal Code. He was sentenced to serve a death in criminal case 718-01. The that was at Garissa. This was on 18th November 2002. That's when he was convicted. Yes, November 2002. So this is Rotu. Sorry. He lodged the appeal number 5/2003 in which, after the same was heard, it was dismissed. Now, subsequently, he lodged the criminal appeal number 32606, which was dismissed also on 15th May 2009.
na ukaanza kuweka mfano ya hapo kukataliwa pia.
He has now moved court for the resentencing dealing with the supreme case of Mwateto.
Na sasa hivi ukarudi kuanza kuomba miaka zako
The prosecution has not
sababu ya
objected to
mwanamke
this,
case
has not objected to this
kwa
prosecution.
upande wa kiongozi wa mashtaka hawapingi hilo.
You see, the court has discretion. You can either sentence or refer the matter to the lower court.
Na upande anaona hawapingi hilo ombi la kuweza
Either for this court to sentence or to refer the matter to the lower court. The applicant says that he has been in custody for 19 years.
Ulisema ya kwamba
He says he has reformed according to what he has told the court, and he has undergone various trainings which he produced documents. He says that the circumstances of the incident subject in this case was stealing of 245 shillings and very minor injuries. The circumstances, he says the sentence was extreme. As the court finds yes, the court has gone through the record and found that and also that the mitigation which were tendered by the accused in the circumstances of this case, the dictate which dictates that this death sentence, which was mandatory, is set aside, and the court finds that the period already served, which is 19 years from the date he was arrested, is enough, and therefore the court orders that he be released, that the sentence served is adequate and he be released forthwith.
Na koti inaweza kuonelea kwamba imetupilia mbali lile kifungo ambalo ulikuwa umefungwa na kifo, na inaonelea kwamba hizi miaka ambazo umeweza kukaa ndani ambazo 19 tangu uweze kufikwa ilitosha ya kifungo lako, na kwa hivyo kuamrisha ya kwamba wewe uweze kuachiliwa.
So,
unaelewa? Sawa. Unaweza enda.
ni sawa sawa. Is that all? Okay, sawa. What else is remaining? I hope you have noted all those, eh? Okay, we do the corrections and then you can be able to get the copies. We are through? Yes. Okay. These others will have to communicate when they can bring them. You can tell them that